Welcome to episode 37 of the Ask the Law Firm Seller Show. My name is Jeremy Poock, and I lead Senior Attorney Match. In today's Ask Show, we will have two questions plus our Poock's post. And just as a preview for our Poock's post today, it's going to focus on the importance of the first 180 days post-closing. So let's jump into our questions today. Our first question today is, I found a buyer for my law firm, but we have not agreed upon terms yet. What do you recommend? Okay, so first question in terms of sellers of law firms, what we're really talking about here are small business law firms typically led by one or more founders. Typically, they are senior attorneys. Those are attorneys that have practiced more than 30 years. They've built their practice over a number of years, and they're often on the lookout at some point for who's going to purchase their practice. So when it comes to finding a buyer and why you haven't reached terms yet, an initial question is, all right, what type of buyer have you found? And what we're showing here is there's really three options when selling a law firm. The first option, which is a preferred option as we've found over the years, is to sell to a growing law firm. Second option is to structure an internal succession plan with one or more internal lawyers at your firm. And then the third option, which really isn't applicable here, is to maintain your status quo. So let's look at that second one first, because what we often find is that senior attorney owners of law firms really hope that they have found a buyer with regard to an internal lawyer who we call a key employee lawyer at their firm, and they've just been struggling to get to terms. So let's explain why that struggle with getting to terms happens with regard to key employee lawyers. And it really comes to risks versus rewards with regard to key employee lawyers. That is, senior attorney sellers of a small business law firm, they think that that their internal key employee lawyers would love to succeed to their turnkey business. It produces revenues, produces profits. Why wouldn't they just want to purchase the firm? They scratch their head on, all right, why haven't we been able to get to terms yet? And what we often find is that those key employee lawyers, when they weigh the rewards versus the risks of purchasing their boss's law firms, often the risks just outweigh the rewards. Even though those rewards mean that they could make more money as the owners. They could change the direction of the law firm and manage it differently from their boss. They also, as good lawyers, issue spot. And those issues that key employee lawyers will spot are, wow, what if we don't originate enough business after the founding rainmaker or attorney or attorneys retire? What if we can't pay for this law firm? What if my work-life balance actually gets worse? I actually have to work harder, bring in more work. If I need to expose myself to personal guarantees of a lease, of a credit line, what if other lawyers or key staff people, what if they leave the firm? And what we find in terms of this question, okay, we haven't been able to reach terms yet. The question to those sellers is, all right, well, your buyer is your buyer either just a key employee lawyer, or is your key employee lawyer someone that really does aspire to own a small business law firm? When the answer comes out that your key employee lawyers do not aspire to purchase their boss's law firms, then our advice is, all right, well, let's consider a different type of buyer. Maybe you haven't reached terms yet because your internal key employee lawyer just doesn't want to purchase your practice. All right, so now let's look at the other option, okay, which is a growing law firm. So when we get those types of calls, when a selling lawyer or sometimes even a purchasing firm will contact us and say, all right, we have found each other, and let's look at this from the perspective of a selling law firm. That is, selling law firm has found a growing law firm, often a friendly competitor in their marketplace that is practicing in similar practice areas. as theirs. They have found each other, they like each other, they respect each other. Often they've even shared clients with each other, or have referral sources, other connections that they've had over the years. Yet they just haven't reached terms yet. And then the question is, all right, why haven't you reached terms yet? And what could help the parties to move forward? And here we're showing is that in our experience, it takes 6 meetings to sell a law firm. So just to rattle off those 6, and then to focus on, why is it that the parties, when they find each other, why haven't they progressed often past meeting number 2? So again, just to rattle off those 6 meetings, first is a meet and greet. You get together, and whether that's for drinks, dinner, lunch, whatnot, and are starting to kick around the idea of, wow, wouldn't it be really interesting if our firms came together, if I sell my firm to your firm? Second meeting is due diligence. All right, let's look at P&Ls. Let's look at billings information. Let's look at staff information, and additional due diligence. Then there is the third meeting, which is, all right, let's negotiate terms of a letter of intent. Then fourth would be sign the letter of intent. Fifth, negotiate an agreement. And sixth is sign the agreement. So where do the parties often get stuck in the mud? What we find is when parties are trying to do the negotiations themselves, and they get stuck in the mud between meetings 2 and 3. So just as a reminder, number 2 is the due diligence. Number 3 is to negotiate a letter of intent. The issue with due diligence is that often the parties don't necessarily know all of the questions to ask. They may have done sales of other types of businesses, but not necessarily a sale of a law firm. So just knowing the right types of documents to be requesting to review as part of due diligence often holds back the parties from going forward. Similarly, when negotiating a letter of intent, right? What are the terms? What's the price? What's the role of selling attorney? What's the role and positions of the lawyers and support staff at the selling attorney? Will they stay on? How will they be paid? How will clients transition? And what we find in terms of giving advice to parties that have found each other but haven't been able to reach terms yet is the value of involving an intermediary. This is certainly something that Senior Attorney Match does, but whether it's us or another intermediary, to have a third party to be able to come in and help the parties, what we call this, when we assist parties that have found each other, selling attorney, purchasing firms that have found each other, we take on a role of what I call deal intermediary. We represent the deal. And as a result, we're able to go to both sides and fulfill due diligence. And we're able to go back and forth between both parties, negotiate terms of a letter of intent. And that allows that proverbial ball to move forward, because you've got an intermediary that can assist with due diligence, negotiate the letter of intent, and also, we find this pretty important too, ask the hard questions. Because when parties find each other, they often are colleagues, even friends, and to ask hard questions. Okay, why did the revenues go down? In this particular practice area, why did such and such an attorney leave your firm, 2 years ago? And then similarly, let's say to the buyer, okay, we see that your revenues have gone up year over year, but they dipped a few years ago. Why? Asking those difficult questions through an intermediary can add a lot of value. And as one of my clients once said to me, he said, Jeremy, I want to maintain as good of a relationship with the buyer as possible, having a broker intermediary available to ask those hard questions so that the parties themselves can always maintain as positive of a relationship as possible. And now let's look between meetings 3, 4, and 5, which is negotiate letter of intent, sign the letter of intent, and negotiate the agreement. Let's look at what those deal terms are, because when parties are looking to negotiate terms of a deal, we can help differentiate between, all right, is this sale going to be a law firm sales 1.0 type of arrangement or law firm sales 2.0? What we find is that many law firms, small business law firms that are led by one or more rainmaker attorneys that have developed a book of business, often the structure is law firm sales 1.0. When a selling law firm is selling that all important book of business, which is comprised of a client list and referral source list, the economic terms typically involve negotiating fee sharing upon the book of business over a negotiated period of time. Said differently, the consideration is often structured mostly as an earnout because buyer has concerns that the clients may not continue with the buying firm. As a result, they put the burden, for lack of a better word, on the seller to say, okay, seller, if your clients do transition over to our firm, we will gladly pay you consideration in the form of fee sharing over time. Sometimes there is some upfront money paid at a closing, but often it's fee sharing attributable to the book of business, negotiated percentages of that fee sharing over a negotiated period of time. Now let's look at law firm sales 2.0. More and more, we are seeing a blend of an earnout plus a fixed price at closing. And that's the differentiator between law firm sales 1.0 and 2.0. And law firm sales 2.0, when a selling law firm can show that that firm is not fully dependent upon one or more rainmaker attorneys for the business, the clients to come into the firm. Instead, a selling firm can show that they have digital value, brand equity, they have real Google Analytics and additional digital analytics that show that such and such a percentage of clients retain the selling law firm because of its digital value and brand equity. A fixed price can be placed upon those value chips, as we call them, the digital value and brand equity. So fixed price paid at a closing based upon that digital value and brand equity, plus earnout terms similar to law firm sales 1.0 based upon the defined book of business, the revenue that comes in from that defined book of business over a negotiated period of time that is fee sharing on that book of business, plus fixed price at closing is what law firm sales 2.0 is. And when parties come together, they have found each other, we can help them differentiate, okay, are we structuring this as law firm sales 1.0 or law firm sales 2.0? Okay. So now for our next question. Our next question is, why do purchasing law firms need to hire the lawyers and support staff of a selling law firm? Okay, thanks for that question. There's really 4 reasons why purchasing law firms need the lawyers and support staff from a selling law firm, and it's broken down into 2 categories. The first 2 needs relate to the clients of a selling law firm, and the second 2 needs relate to the clients of a purchasing law firm. So let's look first at the selling law firm. When it comes to a selling law firm, and why is it that the purchasing firm needs the lawyers and support staff of a selling law firm post-sale? So it's really 2 reasons why the purchasing firm absolutely needs those lawyers and support staff. First and foremost is that when a purchasing firm is purchasing a senior attorney-led firm, they are purchasing the book of business, right? I mean, that's really the driver for why law firm purchases happen, right? That is that clients are the energy source of all law firms, and firms looking to grow, they see that a selling law firm has a book of business of clients. And the question is, all right, who's going to service those clients? Because often purchasing firms, their lawyers, their support staff, they don't have hundreds and thousands of spare billable hours. Okay, the purchasing firm is going to need that experienced workforce of a selling law firm, which is their lawyers and their support staff, to continue to service the clients that the senior attorney-led firm is transitioning to the purchasing firm as part of the purchase. And that really leads us to our second need that the lawyers in particular of a selling law firm fulfill. Because if the value of a selling law firm is its book of business, the way that those clients transition to the growing law firms is via trust transfer. It is so important for clients of a selling law firm to be able to know, like, and trust the lawyers at the purchasing law firm, because the lawyer-client relationship is dependent upon the trust between lawyers and clients. Well, purchasing law firm absolutely needs the lawyers in particular of a selling law firm to continue representing the clients of the selling law firm as they transition to the purchasing firm, and for those clients to be informed, particularly by senior attorney seller, but also very importantly, the lawyers who continue with the purchasing firm, to let those clients know they continue to be in good hands, albeit under a new law firm name, same lawyers, same support staff. We're all here. We continue to work and zealously and competently represent you, the clients of the selling attorney, and we're able to transfer the trust from selling law firm to the purchasing law firm vis-a-vis the lawyers and support staff who continue with the growing law firm. Hence, growing law firm absolutely needs those lawyers and support staff. Now let's look at the other two needs that lawyers and support staff from a selling law firm offer and provide to growing law firms when purchases happen. So when it comes to business development today, we're now in the mid-2020s, we're heading towards 2030. Business development has markedly changed in the legal industry. So much of business development today is transitioning digitally. We're often saying that we're in the age of the vanishing rainmaker. That is, that the rainmakers of yesteryear who would be handing out hundreds, thousands of business cards, developing books of business, having portables that they could bring to other law firms, is really vanishing in front of our eyes and being replaced by digital rainmaker law firms. Those are often purchasing law firms. What we mean by digital rainmaker law firms are firms that are generating business online because clients, let's face it, right? Clients are looking for lawyers online today. They're searching Google, they're searching AI, they are reviewing social media posts in multiple channels of social media. They're reviewing websites, they're listening to podcasts, they're watching videos, all of that happening digitally. So those growing purchasing law firms, who are also these digital rainmaker firms, well, if they're generating the clients, they need talented lawyers and support staff to do the work. Hence that third need that the lawyers and support staff from a selling law firm present is the ability to represent clients that purchasing law firms are generating digitally. And then that leads to the fourth. The fourth need that support staff, lawyers and support staff present to growing law firms is really an interesting need that's being fulfilled, because it's synergistic. What we are finding in the marketplace, and let's focus on lawyers in particular, is that today's lawyers really want a reliable, predictable, and safe job. That is, when law firms are sold, and let's focus on the lawyers in particular, the lawyers at a selling law firm, the key employee lawyers at a selling law firm, what is it that they really want? They want a reliable, predictable, and safe job. Well, that really fulfills a need of a purchasing law firm as well. What does a purchasing law firm want? They want experienced, talented, reliable, and let's add another adjective, stable. They want a stable workforce, don't want turnover. They want lawyers that are going to come to their office and continue to represent their clients, fulfill billable hour quotas, pay the lawyers as well as support staff well, and ideally have those lawyers and support staff continue to practice with them for years and years to come. And by offering the value proposition to lawyers from the selling law firm, that we will provide you with a reliable, predictable, and safe job, fulfills a need for the growing law firm as well, that, wow, we have a need for a stable workforce that will provide high quality legal services to not only the clients of the selling firm that transition to the purchasing firm, but also, or really, and also the clients that purchasing, growing, call it digital rainmaker law firm will continue to generate, and they can rely upon the lawyers from the selling law firm as well as their support staff to assist with representing those clients and producing the all important billable hours or contingency firms, the legal services to meet the needs of the clients of those growing purchasing law firms. Okay, so now for today's Pooks post. Today's Pooks post will focus on the importance of the initial 180 days post closing. So much focus happens in the negotiations of law firm sales on the agreement itself, right? We focus on determining the terms for a letter of intent, then we negotiate an agreement. We sign an agreement. We're all smiles at a closing table. The parties are really focused on accomplishing 4 wins post closing, which are, from the seller standpoint, is to be able to accomplish monetizing the practice. We'll come back to that in just a second. The accomplishment of having key employee lawyers and staff join the purchasing law firm, which is a great accomplishment for sellers to know that their team is able to join them, and they often do, to ensure the continuing representation of a selling law firm's clients at the purchasing law firm. And then it's a huge accomplishment to facilitate growth for a purchasing law firm. What we're not saying at this point when the sales happen is that when law firm to law firm sales occur, and that's what we're talking about here. We're talking in particular about small business law firms that are being sold, and we're selling often a book of business of a small business law firm. Well, often the seller is not just walking away into the sunset. The seller, as part of the consideration, it's often almost all of the consideration is being paid an earnout. It's being paid based upon the revenues that will be derived from that book of business that transition over a number of years to a purchasing law firm. And hence, the first 180 days post-closing are incredibly important for all of the parties, because we want to make sure that we're getting off to a great start on the right foot to make sure that clients are transitioning to the purchasing law firm, as well as senior attorney, him or herself, who's often joining the purchasing firm of counsel or non-equity partner, sometimes equity partner, but most often is of counsel or non-equity partner, to fulfill what we call trust transfer, of transferring the clients to the lawyers at a purchasing growing law firm, as well as transitioning that staff to the growing law firm. So to focus on the importance of the first 180 days actually starts when the agreement is signed. We find that there's a time period between signing an agreement and a commencement date. Often it's only 30 days, can be longer, but it's often 30 days. And where parties can really start on the right foot, or really need to start on the right foot, pre-30 days before the commencement date, is making sure that announcement letters are going out, new client fee agreements are being sent out, a website is ready to go on day one. Really important, right? That you want your clients to know on your website that a transition has happened, on the website of the growing law firm, that all of the lawyers who are joining the firm, their bios are added to the growing firm, because clients are going to be looking for their lawyers. Where are they? Oh, they're at this new firm. Oh, here's the bio. I can connect those dots. Similarly, updating LinkedIn profiles and just a number of logistical items that need to be accomplished pre-commencement date. Then when it comes to days 1 through 180, very, 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 I'll just add a fourth very important, is days 1 through 30, which we call the listening tour. It's so important, even though the parties, got to know each other very well, during negotiations? Well, they haven't like rolled up sleeves yet and started working with each other. And when you start working with another set of lawyers, administrators, staff, it's very easy to be judgmental. It's very easy to, frankly, lose tempers, very easy to get upset. And what we found is an antidote to that. Maybe it's even a vaccine in some respects. Is listening. It's just going into the new firm that's focused on senior attorneys and the attorneys and staff of a senior attorney-led firm that will join the purchasing law firm as listening. Like, what are your procedures? How do you sign up new clients? How do you file lawsuits? How do you handle billing? How do you handle, fill in the blank? Just listen, and listen. And important to also just meet people at the firm. I have a client that just joined a firm a couple of weeks ago. It's very nice. I mean, like that firm, which has absorbed a number of senior attorney-led firms, it's just day after day, lawyers came into her office and just introduced themselves. Welcome to our team. I mean, how special is that? When you just feel welcomed at this firm that you joined, because we're often making the analogy, and it's childish in a way, but it's really true. It's like going to a new high school, right? I mean, like that is the seller. Has been class president in some respects of a very small school, the firm that selling attorney has run often for decades. Now you're joining a new firm. It's like going to a new and much bigger school. Often, not that you're joining like a firm that's an AmLaw 100 or AmLaw 500 even firm, but when you're going from a firm of like 5 people or 10 people and you're joining a firm that's like 20, 30, 40, 50 people, it's like going to a new high school. And just listening, very important. Days 30 through 90 is what we call adapt and adopt, which is it's important, and I'll say important first, but let's get to what's natural second. What's natural we often see post sales in this first 180 days is that both sides, seller and buyer, seller will say, well, this is the way we've always done it. Buyer will say, well, this is the way we do it here. At some point, unfortunately, somebody on the buyer side will take out a metaphorical, we call it sheriff's badge, and will say, well, this is the way we do it here, and that's it. And that really gets like on a Family Feud style, like because it just does not go over well at all. And that adapt and adopt, which really links back to listening, is okay, how can we adapt to each other? Okay, if this is the way, senior attorney, you've done this for so many years, maybe we can learn from you. Maybe we can adopt. Senior attorney, well, if I've done it this way for so long, then maybe I can adopt. And just as an example of a particular firm from a few years ago, we have a client, an estate planning client, amazing rainmaker, great estate planner. The purchasing firm uses a certain document system for estate plans. Well, that system cranks out like 70-page estate plans. It was driving the senior attorney, rainmaking attorney who joined that growing law firm. It was driving him nuts. So what did growing law firm do? Instead of taking out the badge of, hey, this is the way we do it here, tough luck, they said, you know what? Do it your way. All right, we have our systems, we have our processes. Now 95% of our estate planning documents will be on this document system, but we really don't want to rock the boat with you, Mr. Rainmaker, who is bringing in tons of business into this law firm. You've got this great reputation. You are transferring the trust of your non-estate planning clients to us. Why do we want to pick a fight with you? Instead, we're going to adapt. And that can happen, or really should happen, in days 30 through 90. And I can't say that it's not without bruises. Often I'm saying that this is comparable to a bumpy airplane ascent. Okay, we've all been on those. They're not fun. Bumpy, 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 and then get to cruising altitude. And cruising altitude can happen in days 90 through 180 if we've gone through the listening tour, we've adapted and adopted, and then 90 through 180 is when the parties can really start growing together. That's when we're starting to trust each other, sort of know, like, and trust each other. That is lawyers from selling law firm and staff too. Very importantly, like as the saying goes, the judge can hurt you and the clerk can kill you. Well, the lawyer can hurt you, but the parastaff can kill you, right? I mean, we've seen this where the parastaff, where they're not integrating well into purchasing a law firm, can really hurt those first 180 days. But let's just say we've gone through listening tour, we've adapted, we've adopted. Grow together means that selling attorney is now really transitioning clients and referral sources to the growing law firm. The lawyers that have joined growing law firm from selling attorney, they are integrating into teams and practice areas at the growing law firm. There's marketing that is happening to the clients of the selling attorney, letting them know that you now have new and additional resources that the growing law firm has. Really, what the parties were looking to accomplish when they were negotiating the terms, when they start growing together, that's when that can really accomplish and be at cruising altitude, and the parties can have the success and accomplishments that they aimed for when they first came together. So now let's just summarize. When it comes to the importance of the first 180 days after a sale, there's really 4 steps needed to achieve success. The first step to achieve success is that listening tour. Just before parties start judging each other of this is the way we've done it and that's the way we do it, just please, first 30 days, like, listen to each other. Second step is start to adapt, right? Oh, that's how you do it. This is how we do it. Okay, we can do it together. In this way, we can make compromises. We can take the best of yours, best of ours, combine them. It's what we shot for anyhow. It's what we learn in law school as well, right? I mean, when it comes to any case that we're making, right, we are looking at past precedent. Well, what are the facts? How do we take past facts, apply them to these facts, that precedent, and make a stronger case? Very similarly, how do we adapt from the best of both firms? Then we start adopting best practices from both firms. That then leads to the 4th step, which is we grow together. And very importantly, from both sides, from senior attorney seller side, means that I'm starting as the seller to transition my clients to the lawyers at the firm that I have joined. The growing law firm is representing those firms. Senior attorney, of course, from a consideration, monetary value there is getting paid when those clients are transitioning to the growing law firm. Senior attorney is often getting paid on an earn-out basis and is benefiting financially when the firms grow together. And what we often find is, how do we know that we have achieved success? Whether that's within the first 180 days, ideally, or afterwards, it's when senior attorney will often say, wow, I should have done this earlier. And that is episode 37 of the Ask the Law Firm Seller Show.